attorney Dedra Sibley. I am of counsel to the law firm of Allen Arcadier, PA. Today's topic is violation of probation. I've received a lot of questions about what the process is for a violation of probation hearing. It first starts with the person that has been placed on probation for a period of time. When placed on probation, you're required to meet with your probation officer and give a report or status as to your progress. There may be times when a meeting does not occur, or for whatever reason the probation officer feels like you have not complied with the terms and conditions of your probation. At that time, the probation officer will submit an affidavit of violation of probation to a judge. The judge will review the affidavit, look at the allegations made by the probation officer, and if agreed with the allegations made, the judge will sign a warrant for violation of probation. At that time, it is a warrant for the arrest of the person that was on probation. That warrant, along with the affidavit, is then given to the sheriff's office for them to execute on that warrant. That's a simple way of saying there's a warrant for you. The sheriff will be more than likely coming and knocking on your door to execute that warrant for your arrest. At the time that you are arrested on a violation of probation, you will be booked into the county jail and you will go before a judge, usually within 24 hours. That judge will give you your next court date. Most of the time on a violation of probation, it's on a no bond status, which means you will not be able to place another bond and get out before going before the judge that signed the warrant for the arrest. Once you get a time that you go before the judge who signed the warrant for your arrest, you will then get the documentation that shows the reason that the probation officer thinks that there was a violation, basically what the allegations are against you. The judge will then ask you to enter a plea. Either you're going to admit that you violated the probation, or he will most likely set it for a hearing. At that hearing, it is the burden of the state to prove that it was a willful and substantial violation. That means that the burden of proof is that they have to show that it wasn't an arbitrary act or something beyond your control for the reason for the probation. You're entitled to have competent counsel to represent you at that hearing. I would advise you to seek out an attorney who has experience in violation of probation hearings and to consult with that attorney as early in the process as possible.